There were a few articles in the news last week that the federal court system is coming up with new rules to cut down on judge shopping. So I personally think this is a bad idea. As far as I know, there are no rules whatsoever in Massachusetts state trial courts which prohibit judge shopping. And it happens all the time. I know that the judges look down on it. There's some clerks who also don't like it. But it happens very often, and usually when it happens, at least in the criminal law world, it's collaborative. So both the prosecutor and the defense attorney decide that they're going to schedule an important hearing, usually it's the plea, on a day when there's going to be a high likelihood that you'll get a certain judge. Now, this isn't some sort of way to circumvent the law or anything like that. Many judges, most judges, are pretty reasonable, and if the two sides have worked out a plea agreement, the judge is going to go along with the agreement. Okay, the prosecutor and the defense attorney know more in most cases about what's going on than the judge does. So the prosecutor, through the victim witness advocate, has heard from the alleged victim, has been in contact with the witnesses. The prosecutor knows the strength of the case. All right, are they going to be able to produce witnesses? Do they have strong evidence? Is there some evidence that they can't obtain if it went to trial? So they know what sort of position they're in for the plea agreement. And on the other side, the defense counsel also knows very well what his client wants, what sort of disposition is suitable to his client, what's fair, what's not fair, the strength of his case, and so forth. The judge usually doesn't know any of this, okay? The judge usually handles things in sort of an assembly line type manner. So he'll hear a restraining order, an arraignment, a pretrial, and then you go before him with your plea, and the judge will get basically a 2-minute recitation of the facts from the prosecutor. Maybe the judge will look down for 20 seconds or 30 seconds and review the defendant's criminal record. And there are some judges who, with this tiny bit of knowledge, will throw out a plea agreement and come up with their own disposition to the case that the defendant can accept or reject. And often this will just ruin months worth of effort on both sides, the prosecution and the defense counsel, to reach a good resolution to the case. So it's a small minority of judges who will do this, and they'll do it very frequently. And there are lawyers on both sides who try to avoid these judges, and they engage in judge shopping in order to resolve their cases in a fair and reasonable way. So I've written a blog post on this, and I'll put it in the description below.